Hello, everyone. My name is Joey Barnett, and I'm a partner at WR Immigration, and you are listening to Chatting with Charlie, EB-5 Investor Outlook. Today is July 30th, 2024, and I am joined by WR Immigration's Director of Visa Consulting, Charlie Oppenheim, to discuss the EB-5 Immigrant Investor Program and the current status for green cards through that program. Charlie, great to see you today. Thank you for coming on.
Yeah, it's a pleasure to be with you.
And as we always say, this does not constitute legal advice. It's just for informational purposes. And if you want any questions or have specific opinions about certain items for your case, please contact our firm. We'd be happy to help. My email is jbarnett@wolfstorff.com. You can also contact us at visalaw@wolfstorff.com. WR Immigration, we've been around since 1986. We have filed over 5,000 of these EB-5 cases. We are considered one of the top firms in EB-5, and we have been awarded as such and recognized as such by our peers. And we would be happy to help you and your family get green cards through the EB-5 process. Today, we're going to be talking about the August 24 Visa Bulletin. We're going to be talking about the unreserved visa use for fiscal year 2024, which ends in 2 months. And we're going to be talking about projections for the reserve visa categories for the rest of this fiscal year and the upcoming year. And this is incredibly important and a great opportunity based on the new EB-5 law that was enacted in 2022 for those who are in the United States and to file an adjustment of status and to get that green card process started a lot quicker than what you used to be able to. It's also hugely beneficial for those who are in the United States. Maybe they're graduating from school. Maybe they want a backup plan in case there's a layoff from their H-1B employer. Maybe they've already been laid off and it's past the 60-day grace period and they are still in the United States and they don't know what to do. EB-5 is an option for you, and we're very happy for you to listen in. So first, we're going to be talking about the Visa Bulletin for August 2024. This is just an excerpt from the Chart A for the employment-based preference cases. And you see the 4 different visa categories for EB-5, the 1 unreserved, and the 3 set-aside or reserved visa categories. Charlie, my first question to you is, were there any changes from July to August in Chart A?
No, the unreserved dates for China and India remain the same. They've basically been that way for probably the last 6-7 months. I would expect that the China unreserved date to possibly advance up to 2 weeks, and I would not be surprised if the India date advanced some as well, based primarily on the low number use for each so far through May, which is the last information we have posted on the State Department websites.
Right, and we're going to be getting into that a little bit more. And what about, we don't show Chart B here, but Chart B is the date for application filing date, and it's what the Department of State sort of believes where Chart A will be maybe in 8 to 10 months or something like that. It's sort of a forward-looking chart. Do you see, we were talking right before this started recording, what do you see potentially happening for Chart B unreserved for China mainland born?
I believe the China mainland unreserved date in Chart B is currently January 1st of 2017. Based on my discussions with State Department officials at an Atlanta II-USA conference, I believe that China date will be retrogressed to someplace in 2016.
So if you're in the United States and you haven't filed for an adjustment of status yet, I don't think they're actually allowing Chart B anymore for adjustment of status. That's something that USCIS normally allows in the beginning of a fiscal year when more visas are available, but it doesn't believe you can do that anymore. But that is something that we are keeping our eye out on because it does impact a lot of clients. I mean, one thing that I want you to clarify, Charlie, is, if you are current under Chart B, that doesn't mean you're going to be getting an interview scheduled at a U.S. consulate abroad, right?
No, the Chart A governs the actual scheduling of interviews. Chart B only allows applicants to begin submitting their documentation so that their case can be worked on at either the National Visa Center if processing overseas or by USCIS for adjustment of status cases, so that when and if the final action date were to advance, the case would be ready for final action quickly.
And so in this instance, we have a number of Chinese unreserved EB-5 investors who filed in 2016, who are current under Chart B, who have gotten the fee bills paid, who have become documentarily qualified with NVC, and is now just waiting for the U.S. consulate in Guangzhou to schedule the interview. They, however, can't schedule the interview until the priority date is current under Chart A. So that's kind of a predicament that we're having. And even the bigger issue that we're seeing here is the difference in how the Department of State calculates a child's age under the Child Status Protection Act compared to USCIS. In USCIS, you can use Chart B to lock in a child's age, but the Department of State only allows folks to take action based on Chart A to lock in a child's age. And because of this long backlog, there is actually like kind of some systematic, these delays are sort of creating systematic age outs. And we need the Department of State to change their interpretation so that it's consistent with USCIS, so that U.S. immigration law is followed the same no matter whether you're in the United States or outside of the United States. From my point of view, that determination shouldn't be based on where you currently are. And that's something that I really, really hope the Department of State can look into, and they can see why this is so important to keep families together. Charlie, let me ask you about Chart A for the set-aside categories. Those were created back in 2022. They've been current since then. Can you explain why they've been current, and do you expect them to remain current for the next 2 months through the end of fiscal year 2024? And what do you expect to happen in the future?
Sure. A final action date, which would be listed in Chart A, should only be imposed when the amount of actual number use for the current fiscal year and estimated use for the remainder of the year would exceed the annual limit. That has not been the case. There have been virtually no visas being issued in any of the reserved categories, which is allowing them to have been listed as current. They will remain current for the month of September, and I believe they will be current for fiscal 2025 until at least the summer. It's possible a reserved final action date of some type would have to be imposed in the summer of 2025 if the approval rate and actual number rate were to increase dramatically from what it is now. But again, that is too early to call, but a worst case would be summer of 2025. But I do believe that reserved final action dates will need to be imposed at some point in fiscal 2026.
Thank you. And so that's based on a number of things, right? It's based on how quickly USCIS processes I-526Es. It's based on how quickly USCIS transfers cases to NVC after approval of the I-526. It's based on how quickly a U.S. consulate schedules an interview for those people and actually use those visa numbers. I think the Department of State said at the IIUSA conference that under 20 reserve visa numbers had been used this fiscal year. And I think all of them, if not a large majority of them, have come based on adjustment of status applications in the United States. I know our firm has gotten a number of them, but it's still not significant enough to show a demand that exceeds the supply and thus the need to impose a final action date. Did I get that right, Charlie?
Yes, you did. And this shows why anybody that is contemplating these reserved categories, it's extremely important for them to act in a timely manner, especially with the USCIS allowing the application filing dates to be used. They typically allow those dates to be used each fiscal year until somewhere in the January to March timeframe. So I would expect immigration to be allowing Chart B to be used beginning in October, but it's extremely important for people to act quickly and get their paperwork in while they can.
Right. And the big benefit of this for those who are in the United States is you get your adjustment of status application filed when you file the I-526. And with that, you can file for an employment authorization document for unrestricted work access and for advanced parole to travel in and out of the country during the time in which the adjustment of status is pending. It gives you a lot of flexibility. I'm thinking about people who are on an F1 and graduating, or getting through OPT and can't find an H-1B employer to sponsor them to remain in the United States. I'm thinking about people who are on a backup plan, who are on an H-1B and are scared about layoffs, or those who have actually already been laid off and maybe they're past the 60-day grace period. They haven't been able to transfer to a new employer, but they've remained in the United States. Well, EB-5 could be a potential path for them because there is some protection for being out of status for a certain period of time under 245K, which is also new under the EB-5 law. So there's a lot of opportunities here for people to remain in the United States and to forge a new pathway. You know, we've talked about this before, Charlie, but there's no problem being in 2 or 3 separate visa lines, right? You can have an EB-2, an EB-3, an EB-1, and an EB-5, right? I mean, there's no restrictions on that.
Correct. You can file in as many preference categories as you are eligible. And this is an extremely good benefit because if you have the means to do so, you may be an Indian second preference or third preference applicant, or China second or third, and have the means to file under one of the reserved categories. This would provide you with an extra opportunity. And whichever category is reached first, that is the one you would be processed under.
Excellent. All right, so now we're going to look into more historic. Well, we're going to be looking at fiscal year 2024 visa use. This year, there are more EB-5 visa numbers than ever before, and that's because of the carryover provisions that are in the EB-5 Reform Act, as well as the high annual limits that were created in prior fiscal years because of unused family-based numbers that didn't happen because of the COVID restriction era and the lack of family-based processing then. And so in fiscal year 2024, there's over 14,000 unreserved visa numbers and over 8,000 reserved visa numbers. Those 8,136 reserved visa numbers, we're not close to using those, right? They haven't approved enough I-526Es to use up those reserved visa numbers. Now, I don't know if they've even scheduled any consular interviews for post-RIA investors abroad. Our firm has not had any. At the IIUSA event, they indicated that there was one scheduled because of an expedite that was approved. This is something that we are sort of scratching our heads at and maybe shaking our fists at, because there's nothing stopping them from scheduling these interviews and from getting these reserved visa numbers to be used, right, Charlie? There's nothing stopping them from doing that.
Correct. There are plenty of numbers available. It's just they do not have enough applicants with approved petitions that they're scheduling interviews now. It's a very unfortunate event. The bill was passed in March of 2022. There were no visa numbers used in 2022, none in 23, and there will be only minimal used in fiscal 2024. That is a very unfortunate situation when you have large amounts of numbers available for potential use and you're not using them and having them, in a sense, go to waste when there are plenty of reserved applicants who could use them.
Yeah, because there's over 6,000 reserved visa numbers that have carried over to the unreserved category. And if those don't get used this fiscal year, then they're going to be lost. Well, actually, let me pause that, because they've already used 7,173. And they have indicated that those carryover visa numbers are going to be used first. So none of those carryovers should technically be lost, but the balance, the fiscal year 2024 unreserved allocation, those likely will be lost unless we see a huge pickup in consular processing or adjustment of status applications. You know, through May of 2024, they have used just over half of the number of unreserved visas. And this chart here, which we are taking these charts from IIUSA, Thank you, Lee, for all your great work that you do on this. We appreciate you letting us copy these and use these. You can see that it sort of is tracking along with what happened last year in fiscal year 2023, but it's a little bit above. So it's better than last year, but we have more visas this year than last year. And the question really becomes, how is the Department of State going to use and allocate the remaining 6,500 that have not been used at least through May? Now, we're getting a lot of interview notices for Chinese applicants who filed in 2015, and they are scheduled to occur before September 30th. But I don't know if it's up to the level that we need so that there are no wasted visas. Charlie, what are your thoughts on that? I mean, is it realistic for the U.S. consulate in Guangzhou to issue another, 4,000, 5,000 visa numbers in the next 2 months?
I think it may be very difficult. Typically, we would try to slow down number use during the summer months because the foreign service officers often are transferring posts during the summer months, and the non-immigrant visa workload is increased, sometimes drawing immigrant visa staff away if there is a high demand for non-immigrant visas and they need to shift staffing around to accommodate that. So I think it will be very difficult. The one, and this is kind of perplexing in terms of why the China date has not moved forward and why the India date has not moved forward so far this year. I have two possible reasons. One is that the amount of rest of world demand is very high, and they believe that such number use will allow the 14,000-ish limit to be reached. That would be very beneficial because if they're taking care of a lot of the rest of world demand, that may allow for more China unreserved use in the future. The other issue is that there's just not the processing capacity at Guangzhou, which is limiting the amount of cases being scheduled. And one final possibility is if there are Chinese applicants that have been previously interviewed and they may not have had one of the required documents, they're going to be a, quote, comeback case, or the Department of State is having to do updated clearance processing. They may be able to basically issue a lot of visas in the August and September timeframe if those clearances and documents are returned to them, because they may not have to go through the full interview process.
Right. And I mean, I'm just looking at the numbers on this graph right here. There's 4 months left in fiscal year 2024 that we don't see here with the green bars. If all of them were to be used, it would be over 1,500 numbers a month. That hasn't happened for the past year and 9 months. I don't know if it's realistic to expect that they're going to increase. Now, I do remember a couple of years back, they did have an extremely high number of visas issued out of Guangzhou. I think it was August of 2022. And maybe we'll see something similar this year. And our fingers are crossed because we need to clear out the backlog. We need to get the 2016 Chinese investors scheduled. And as we mentioned before, we really need to get those reserve visa numbers used now so that there isn't any wasted numbers that go to EB-1 and then down to EB-2 and EB-3.
Right. And as you mentioned, that 2022 excessive over 2,000 numbers being used in a single month, that speaks to my point where I believe some of those were actual interviews during that month. But I think a large amount of them were likely to be the comeback cases I mentioned, where Guangzhou was only awaiting the applicant to return with a needed document or a clearance, so that the actual final issuance of the visa was essentially a paper transaction once they received that information. And again, that is my hope. That's what's going to potentially be happening this year with the China demand.
Got it. Good point. All right. So this gets to how many visa numbers have been issued in the unreserved visa category. The last slide was overall based on all consulates. This is on a to-date annual so far in fiscal year 2024. And you can see that China has gotten over 60% of the visa numbers. This, to me, Charlie, kind of pushes back on, hey, they're pushing through the rest of world visa numbers because it's not high really for too many other countries.
Correct.
Either way, it does show that pretty much the main beneficiaries to date, at least consular processing, are China, Vietnam, India, and Taiwan. And that's pretty consistent with years past. Again, this has to do only with the unreserved visa category. Charlie, you have anything to add here?
Well, you mentioned India, where India has only used 512 numbers through May. The per country limit this year is approximately 990 numbers. That's going to mean that India is going to have to use an average of about 120 numbers per month just to reach that per country limit. And with the exception of 1 month, India has only been in the double-digit number use through May. And I find this kind of troubling in a way because there was over 1,600 Indian applicants with petitions on file when the National Visa Center report as of November 1st of 2023 was published. And this is, this low number use of 512 versus the annual limit of 992 is a little troubling and calls into question, why hasn't that India final action date been advanced to allow more Indian applicants to use numbers? It will be extremely unfortunate, and that would be saying it mildly, if the fiscal 2024 unreserved annual limit is not reached. So hopefully there will be a concerted effort by the State Department and USCIS to be processing cases during the summer months.
And before we talk about Vietnam, which you can see actually exceeds the fiscal year unreserved limit, and I'll let you explain why, I just want to make sure that everyone understands these numbers here are only for consular processing. So it is possible that more unreserved visa numbers have been given to Indian nationals or Chinese nationals in the United States through an adjustment of status as well. But Charlie, we've talked about this in the past, but for people who haven't listened to all of our prior sessions, there was a huge amount of visa numbers given to Vietnamese in the beginning of the fiscal year that has since tapered off, but it exceeds the annual limit. Can you just give us a quick, maybe 30 seconds on why you think that happened?
Yeah, I think the excessive amount of visas that were issued in the first quarter of the fiscal year, being October through December, I think, again, that was probably based on comeback cases where the Vietnamese applicants may have been initially interviewed in fiscal 2023. They were lacking a document or a final clearance, and that information came through, allowing them to be issued in the October-November timeframe. The second point, to your point I mentioned earlier that the annual limit is 992, and so far through May, that Vietnam number use is almost 1,400 numbers. And that is because if there are unused Vietnam family-sponsored numbers, those family-sponsored numbers can fall down and be used in the employment-based categories. And I believe any of those fall-down numbers should be apportioned based on the percentages assigned in the INA to the first, second, third, fourth, and fifth preference categories. And therefore, that fall down provision so far is allowing Vietnam to use more numbers. One interesting point is that the National Visa Center's waiting list report of applicants from Vietnam with petitions on file as of November 1st of 2023 was only 571, yet they've already used 1,385 numbers. This kind of argues to the point that there are a lot of Vietnamese applicants being processed as USCIS adjustment of status cases. And this could bode well for the Indian number use total as well. Maybe that will bump up the Indian number use total because the Indian applicants and Vietnamese applicants potentially were already in the U.S. on another type of visa, where that would be less likely to be happening with the China applicants for the unreserved category.
That makes sense. Thank you. Okay. And then this just shows historic EB-5 visa use over the years. You can see we're kind of back to where it was before COVID, which is great to see. And actually, we're kind of where it was back in 2014. I know last year they used all of the unreserved visas, and I'm hopeful that they do that again. The difference between the blue and the gray in this chart is the gray is adjustment of status applications, where the blue is consular processing at U.S. consulates or embassies abroad. And I am very, very hopeful that we get this blue bar to be over 10,000 this year. I mean, that's certainly the goal. Charlie, anything you want to add to this? I know it's just the historic use.
Yeah, just one, as you say, it's returning to the historical norm. One good thing is the 2023 number use was lower in the early part of the year. And then there was a concerted effort by the State Department to maximize EB-5 unreserved number use during the summer months. And again, that is something we just have to hope for, and that we will see that the number use during the summer months exceeds that of the first part of the year.
Great. And finally, just for those who didn't catch it earlier, Charlie, could you put your wizard hat on and just give us your thoughts about the outlook for the reserved or set aside visa categories for the rest of fiscal year? Are people still going to be able to file an adjustment of status application with their EB-5 case?
Yes, they are. The 3 reserve categories will remain current for the remainder of fiscal 2024. I believe that the 3 reserve categories will remain current for at least through May of 2025. In a worst case scenario, it may be necessary to impose some type of final action date in the summer of 2025. But I do believe that final action dates will be imposed on the reserve categories during fiscal 2026. I also believe that the USCIS will allow the Chart B dates to be utilized beginning in October and likely to be through at least January, possibly as much as March. Again, it is very important for everybody to file in a timely manner and appear for your interviews and finalize action if you're processing overseas. But again, I think we're in good times for the foreseeable future based on the amount of numbers currently available. But that could change if there is a dramatic shift in the approval rate and final processing of cases being scheduled for number use next year. And we'll just have to wait and see.
Yeah, unfortunately, it is a wait and see, and we have this wizard with a crystal ball because it is somewhat opaque, and it's hard to know really when these final action dates will be imposed. But thankfully, we have Charlie to help guide us. So we thank you for your insight and contributions today, Charlie. And that ends our webinar today. If you'd like, feel free to reach out to us. Here are our QR codes. I'll leave them up for the next 5-10 seconds so you can take out your phones and scan them. Or if you have questions about EB-5 and you just want to reach out to me directly, you can email me. My email address is jbarnett@wolfstorff.com. Thank you so very much for listening today. Hope you have a great summer.